Notice, I call up H.R. 6048, the NDO Fairness Act, for purpose of markup. Move the committee reported favorably to the House. The clerk will report the bill.
H.R. 6048.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Chairman. I'm proud to partner with my colleague on the other side of the aisle, Congressman Nadler, once again, in introducing the NDO Fairness Act. This bill makes much-needed changes to the way law enforcement obtains the use of non-disclosure orders, also known as secrecy orders. The evolution of cloud computing has significantly changed the way we retain and store personal information. Before cloud computing, the Fourth Amendment required law enforcement to execute a search warrant and subpoena the items they wish to view. The officer executing the search would leave behind a copy of the warrant and an inventory of the property seized. Congress altered this process in 2001, with passage of the U.S. Patriot Act, allowing law enforcement to execute an unannounced search, provided that no property was seized. This process, known as the sneak and peek, required the same probable cause standard as the Fourth Amendment search, but required the party affected by the search to be notified within 30 days rather than immediately after the search. However, in law enforcement wishes to search emails, files, and other data stored on the cloud, the officer never has to give notice to the individual. Instead, they serve the subpoena to the cloud computing company along with a non-disclosure order, or NDO, prohibiting the company from notifying the individual of the search. All, I might add, without prior review by the courts. This has led to an abuse of secrecy orders whereby companies like Microsoft, Facebook, and Google receive thousands of boilerplate secrecy orders per year that are unsupported by any legal or factual basis. And you don't have to look much further than what we just saw with the recent revelations by this committee that former Special Counsel Jack Smith sought and obtained non-disclosure orders to prevent phone carriers from notifying members of Congress that their phone records had been searched. For more than a year, members of Congress were unable to be notified that their information was searched, all because the federal judge accepted the government's boilerplate secrecy order, suggesting disclosure would seriously jeopardize an ongoing investigation. Regardless of your politics, this should alarm every sitting member of Congress. The NDO Fairness Act will make needed changes to the secrecy order process by eliminating the boilerplate orders used by law enforcement. Rather than a blind assertion that the disclosure would seriously jeopardize the investigation, the court must certify that disclosing the search is likely to result in the destruction of evidence or endanger the life of an individual. NDO Fairness Act would also impose a limit on the length of the secrecy order, something that does not currently exist in statute. Our bill ends indefinite secrecy orders and imposes a 90-day limit, with an extension available if, and only if, the need for secrecy is justified beyond the facts and approval by a judge. This brings the NDO approval process in line with sneak and peek searches. Finally, our bill allows the individual subject to search to request a copy of the information that was disclosed. These changes, I believe, will be more closely aligned with searches of the virtual data and with searches of physical offices, while protecting user privacy in the process. In closing, I'll just remind my colleagues that this bill, it did pass the House nearly unanimously in the previous two Congresses. So I would urge for the swift passage of this bill, and I would yield back.
Exactly.
Chair, the gentleman yields back. The chair now recognizes the ranking member for a statement.
And thank you very much, Mr. Chairman. I want to salute Mr. Fitzgerald and Mr. Nadler for their unswerving devotion to this bill, whose passage is more timely than ever. This committee is, of course, at its strongest, Mr. Chairman, when we work together across the aisle to safeguard American civil liberties, civil rights, and privacy. And I'm pleased that that's exactly what's happening with this bill, the NDO Fairness Act today. Under the Stored Communications Act, the government can ask a grand jury for a subpoena to search the information that Americans store with third-party providers, including email, private messages, work documents, and phone records. This authority relates to non-content information, metadata, essentially the kind of information that you find on your phone bill, and not the actual substance or content of a communication. Unlike with searches pursuant to a warrant, where the government has an obligation to provide notice to the person whose property is being searched, the Stored Communications Act allows prosecutors to seek a non-disclosure order from a federal judge, preventing the service provider from ever telling you that your email account or your phone records were actually searched. There are good reasons why prosecutors might need or want such an order. In some cases, immediate notice might put an undercover agent in danger or risk the destruction of evidence or compromise an ongoing investigation. But 40 years after passage of this act, the government's use of non-disclosure orders has expanded far beyond these emergency cases. Under current law, the request has become little more than a perfunctory box-checking exercise. The statute allows the government to maintain these NDOs indefinitely. Under current DOJ policy, which at least attempts to curb the practice by placing some limit on the duration, you're still unlikely to receive notice of the government search of your records from your phone company or email provider for 3 years after it started. Better rules are needed by limiting non-disclosure orders to 90 days with the possibility of renewal. The NDO Fairness Act ends forever NDOs where non-disclosure orders have no end date. By requiring prosecutors to explain the actual rationale for the request, we end rubber stamp NDOs in which applications are submitted with boilerplate language and no evidence demonstrating any real need is ever adduced. And by ensuring that judges apply a strict scrutiny standard, we limit non-disclosure orders to those where secrecy is actually necessary. In this way, the NDO Fairness Act will protect all Americans who keep an increasingly large percentage of our information online, and we should know if the government is rifling our records, as the chairman has repeatedly said. Although the NDO Fairness Act has been a good idea for a long time when these gentlemen brought it forward, we are obviously moving this bill today in response to the $1 million bonanza jackpot provision for lucky senators that appeared in the funding legislation passed last week. All of this goes back to 2022 when Attorney General Garland appointed Jack Smith special counsel to investigate President Trump's campaign to overturn the results of the 2020 election, a campaign that culminated in the attack on the Capitol on January 6, 2021. In the days before the attack, while the mob was still rampaging in the Capitol, President Trump and some of his associates placed a series of phone calls to members of Congress to convince them to stop the proceedings and not to certify the election, even as the insurrectionists were violently tearing through the building and driving us out of our chambers. As part of his investigation, Special Counsel Smith asked a grand jury to subpoena the phone companies for the records associated with 8 GOP senators and 1 Republican representative known to have been in contact with the White House during this period. The subpoenas sought call records, the kind of information you find on your phone bill with calls made and calls received. He also asked the judge to issue a non-disclosure order for the subpoenas. He did so only after getting permission from the Public Integrity Section and in full compliance with the law and DOJ policy. In other words, they were treated exactly like every other American is treated in similar circumstances. It turns out that the senators learned from the Volume 1 of the Smith Report that their records had been subpoenaed, and they didn't like it. So rather than trying to change the law, adopting this legislation, or improving everybody's civil liberties and everybody's privacy, they instead wrote themselves a little sweetheart provision to give themselves the right to get a $500,000 payoff for the original grand jury subpoena and another $500,000 for the non-disclosure order. And that's just for one piece of technology, like say a campaign phone, that's $1 million. And then for a personal phone, that's another $1 million, and so on. Now, I can understand the objection to having the Department of Justice rifling through your phone records or your email records. And I can understand the objection to the NDOs that subjected these reports to secrecy. But it's something we should deal with for all Americans and not cut a special deal just for senators. It doesn't even apply to members of the House or governors or mayors, but we're not engaged in special pleading. We want to legislate in the interest of all Americans, and so I applaud the efforts of my colleagues on both sides of the aisle to actually do this in this legislation, and I thank them for their leadership. I look forward to voting yes, and I hope it is a unanimous endorsement by the committee. Yield back to you, Mr. Chairman.
Gentleman yields back. Who seeks recognition? Oh, I'm sorry, that's that. Without objection, all of the opening statements will be included in the record. We have to do the amendment in the nature of a substitute. The chair now recognizes the gentleman from Wisconsin to offer that amendment in the nature of a substitute.
Yeah, Mr. Chairman, I do have an amendment at the desk. This is an amendment that simply adds the year to the title. It in no way alters the integrity or the purpose of the bill.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of substitute will be considered as read and shall be considered base text for the purpose of amendment. Now, who seeks recognition? The gentleman from New York. Yeah.
I move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. The NDO Fairness Act is a simple, straightforward, and bipartisan bill that addresses a narrow problem. By establishing essential guardrails for when the government seeks to access someone's electronic communications without that person's knowledge, this legislation would insert balance into a system that for too long has been a free-for-all for government prosecutors. Under current law, after the government obtains a court's permission under the Stored Communications Act to search the contents of a person's electronic communications, prosecutors must then compel the email service provider to produce the relevant data. To avoid having the service provider turn around and tell its customers about the search, the government can also ask the court to grant a non-disclosure order, or NDO, colloquially referred to as a secrecy or gag order. When the order is granted, the provider, be it Apple, Google, Microsoft, or a similar company, is unable to inform anyone of the search, even a company attorney in the case of corporate clients. There is no time limit to these orders. There is no standard to meet. Today, all the government needs to do is cite 1 of 5 potential adverse effects without showing that it is necessary. And the court may grant the request. In the absence of basic rules of the road, prosecutors frequently take advantage of the rubber stamp approval process to acquire NDOs in cases not contemplated by the underlying statute. This includes cases where there is clearly no need for secrecy, such as where a physical search has already occurred, cases where the search is being done on a victim's communications, and cases where the gag order is placed on an institution not suspected of wrongdoing. In all the situations I just described, prosecutors have no cognizable reason under the law to acquire an NDO, yet they frequently do it anyway. These delays don't simply inconvenience the subject of a search, and the negative impacts are not limited to the theoretical or ideological. NDOs are being used to win cases. Rather than providing Americans with meaningful notice that their private electronic records are being accessed in a criminal investigation, the Department of Justice has too often hidden behind its ability to ask third-party providers directly. This denies American citizens, companies, institutions their basic day in court, and instead allows the department to gather its evidence entirely in secret. To be clear, this has been a problem across both Democratic and Republican administrations. This is not a new phenomenon, and addressing it does not require $500,000 payments to a few affected senators. It requires a change in the law. This legislation would do exactly that. The NDO Fairness Act would ensure that gag order requests are only granted in cases where there is no less restrictive alternative and where the court finds that the notification will likely result in endangering the safety of an individual, flight from prosecution, destruction of evidence, intimidation of witnesses, or otherwise jeopardize an investigation. It would also place strict time limits on how long an NDO may be in effect. Finally, by setting a strict scrutiny standard requiring written decisions based on specific and articulable facts and establishing standing for providers, the NDO Fairness Act would cut down on the number of rubber-stamped NDOs. With advancements in technology and the related surge in electronic correspondence, Federal prosecutors have increasingly relied on the Stored Communications Act and the archaic protections built into that law to search emails. There are many people who follow this issue closely who are concerned about government abuse of the Stored Communications Act more broadly. I am one of them. But those are bigger fights for another day. What we are doing here is instituting a narrow, elegant solution to a simple problem. The NDO Fairness Act will insert process and deliberation into gag order requests and make it more likely that Americans whose electronic communications are searched can assert their rights in court. I was proud to join Mr. Fitzgerald in sponsoring this bill, and I thank the chairman for bringing it before the committee. We have passed this legislation previously on a broad bipartisan basis, and I urge my colleagues to do so again today. I yield back the balance of my time.
The gentleman yields back. Before recognizing the gentleman from Wisconsin for a technical amendment, I would just add maybe two things, two thoughts. One, I agree with the ranking member. I think probably every member of this committee that we need to get rid of the payment that was inserted into the continuing resolution. The other thing I would point out is the ranking member talked about, I think he said 8 members of the United States Senate who had their records, their phone records seized by Mr. Smith or the government and or Mr. Smith when Arctic Frost became part of the special counsel's investigation. My guess is it's a lot more. My guess is it's a lot more because when we deposed one of Jack Smith's top deputies, Mr. Wyndham, he actually told us when we asked him the question, well, actually I say it this way, when we asked him the question, how many other members of Congress did you guys get the phone records on? He took the Fifth Amendment to that. My guess is it's a much bigger number, not to mention the hundreds and hundreds of Americans who were also caught up in Mr. Smith's investigation. Finally, to this bill, this is a good bill. I appreciate the work of the gentleman from Wisconsin, the gentleman from New York. It is a good bill that raises the threshold for when these orders, these gag orders, these non-disclosure orders are actually put in place. And maybe most importantly, and the ranking member mentioned this, it limits the time, 90 days. What we've seen here is years and years of the individual, the American citizen who has his records taken by the government, years they go without knowing that the carrier had in fact given that to the government. And the reason the carrier didn't give it to the government is because the government asked him and the judge said you can't do it. So this is limiting that time significantly. We think that's a good thing. And of course, it has exceptions for children who are exploited in those kind of cases. So this is a good piece of legislation. It's great to see the committee come together on that. Be happy to yield to the ranking member.
Mr. Chairman, thank you so much, and thank you for pointing out that it may have even gone beyond those 8. One of the many problems with the $1 million rider over on the Senate side was, I think, there was a Republican member of the House, I think Mr. Kelly from Pennsylvania, who himself was subjected to the exact same treatment, and they didn't even include him in the bill because he was a member of the House. So I'm happy to represent him in an equal protection lawsuit if they don't repeal this legislation, but I hope they will. And I just want to point out along those lines that this was not the first time it happened, that it had happened under the prior administration with a number of Democratic members of the House who also had their pen records, their phone records surveilled by the government. And I know that happened to our colleague, Ms. Ocasio-Cortez.
And that's the point. This is a separation of powers issue. This is our ability to do our jobs as legislators in the legislative branch of the government. So again, great work here, and I would urge the adoption of and passage of the bill. But first, we got to do a technical amendment. So I recognize the gentleman from Wisconsin.
Mr. Chairman, there's another amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain.
Yeah, Chairman, this amendment just simply corrects what is an error in the bill by rephrasing the language in Section 2, subparagraph B1.
Gentleman yields back.
Mr. Chairman.
I just want to let people take a look at this, just so everyone's comfortable. Mr. Goldman? Oh, the gentleman from New York is recognized.
I move to strike the last word.
Gentleman's recognized.
I just want to respond to what you were saying about what you were discussing in terms of the phone records. And I think it's really important for the American public to understand what we are talking about. We are not talking about the substance of any communications. We are not talking about the subscriber information of anyone that those lawmakers were talking to. When you are conducting a criminal investigation and you have identified wrongdoing, it is very important to corroborate the story. One important way of doing that is to figure out when people were in communication. Because you may have witnesses saying, oh, this person called that person. And you need to figure out whether that is accurate or not so that you are verifying the information you have. This was not surveillance. This was not real-time wiretapping. This was not a search warrant for any communications. This was part of a broad investigation into a large conspiracy to overturn the 2020 election. Now, I understand that my colleagues on the other side of the aisle take issue with that and think that that was somehow bogus. But if you read the 40-plus page indictment, you will see the exhaustive evidence that the special counsel uncovered about a massive, widespread, multi-pronged effort led by the President of the United States to overturn the election. That is what the grand jury ultimately ratified and voted for. And I am confident that if Donald Trump did not win this election and he went to trial, he would be convicted by a jury of 12. We'll never know because he's President of the United States, so the case was dismissed. But this is not some rogue effort by the Department of Justice to surveil senators or members of the House. And what I would suggest is if people don't want a log of the communications that they have made to be subpoenaed by the Department of Justice, don't engage in crimes. Then you will not have your information taken. But there's nothing here that is done in any way that is outside the scope of any criminal investigation. And if we are now going to say that the Department of Justice cannot investigate any of us, then we are free to engage in as much public corruption as we want, because now they can't get our phone records. They can't see if we are actually communicating with someone who's giving us, like, say, $50,000 of cash in a bag. I think that conduct should be investigated. And I think if I do that, that conduct should be investigated as to me. And so the notion that this was some grand conspiracy to surveil senators and members of the House when it was part of a large investigation that was indicted and charged is preposterous. So stop over-exaggerating what happened. This was not surveillance. This was not some dragnet that's trying to wrap in the members of Congress and senators. This is corroborating evidence to confirm what witnesses said. That is part of any federal investigation. And if you are going to prevent that from lawmakers, you are preventing the Department of Justice from doing its job if we had a normal, traditional Department of Justice that was nonpartisan and that was simply trying to follow the facts and the evidence. That is exactly what you would do, is to get these phone records.
Gentlemen,
Yes, I yield to the
well, I want to thank you for that important illumination and clarification here. This is a critical law enforcement tool, and what this legislation does, and I'll let the authors expound if they'd like, is to strike the right balance so it's not being abused. But your point about January 6th, of course, is absolutely right, which is there were hundreds and hundreds, if not thousands, of crimes committed that day, from violently assaulting law enforcement officers to trespass into the Capitol to seditious conspiracy, which many people were convicted of. And so it made sense for there to be an investigation. And all this legislation does is to say we need reforms to it from before that time and after that time as well.
Gentleman is back. The gentleman from New York yields. I would Well, I'll recognize the gentleman from Arizona, and maybe he'll yield some time when he's finished.
Yeah, thank you, Mr. Chairman. I have a question for the sponsor of the bill.
Yes.
Does this bill in any way prevent law enforcement from looking at members of Congress and their phone records?
No, I think that was kind of the idea, and I think Congressman Adler referred to it earlier. We're just trying to reset the process here. We're certainly not trying to carve out members of Congress. And I understand the circumstances, you know, the J6 stuff is unique, as we just, you know, alluded to what we saw with this current situation where the senators, obviously, their records were reviewed. But no, we're not trying to carve anything out here. I think we're just trying to reset the process.
Thank you. Mr. Chairman, I'll yield to you.
Yeah, I mean, the executive branch can't go to the legislative branch and say, we want all their phone records. We're going to talk about dozens of people, I think, when this is all done. We want all their phone records. And oh, by the way, carriers, you can't tell them that they have it and have that information for years and the subject doesn't know it. And all this bill says is you can do what Mr. Goldman just described, but you got to tell them after 90 days. You can't go years without telling them. That's the outrageous part. So we're saying 90 days, and if it's some kind of investigation somewhere where there's an exception, that's in the bill too. That's what this does. That's why it's a good piece of legislation. I do think it's timely in light of what's happened, what we've learned, and frankly, what the Senate did. But that's what it does, and that's an important check, and that's why I wish this bill would have passed a long time ago. But here we are. Let's pass it.
Will the gentleman yield?
It's Mr.
Yeah, thank you. So I would like it even in a shorter period of time before you have to go back and renew. But I'll live with a 90. But I mean, this applies to everybody. There's no carve out for members of Congress.
All Americans.
Right, Mr. Chairman?
Exactly right. All Americans, and maybe you shouldn't have judges just automatically signing these, particularly when you're thinking about members of Congress. That's another issue I think we have to think about. But that's the concern.
Thank you. I'm going to support this bill. I would have preferred that you have to come back more often to get your authorization, your reauthorization, and that you provide the information sooner in a more timely fashion to the American citizen. I mean, we just had a lengthy discussion about that included due process, and it just seems to me like you're invading. And looking at my phone records, I'd sure like to know about it a lot, as soon as I possibly could hear about it, that you're looking at it. So that's the only reason I would say that I wish this would come back sooner instead of 90 days. But with that, Mr. Chairman.
Could the gentleman yield?
Yeah, I'll yield to you.
Thank you. I understand we've actually been passing Mr. Fitzgerald's bill, Mr. Nadler's bill. It's repeatedly rebuffed in the Senate on the grounds that it impinges too much on the law enforcement function. So we're in this great ironic situation where, as a matter of policy, we've been advancing a far more civil libertarian, privacy protective position. The GOP-controlled majority has rejected it repeatedly, and yet when it came to bounce on them, then they decided they wanted the $1 million payout. And I understand that the 90 days, because I agree with the gentleman from Arizona, the 90 days was negotiated up by the Senate. We came in originally with a 30-day proposition.
Back to you, Mr. Chairman.
Yeah. Well,
Gentleman yield.
I find myself in strong agreement with the ranking member.
Mr. Biggs, will you yield for your last minute?
I think he's
I've already yielded to the Chairman.
I'm just
I'm
going to
sorry.
agree with the ranking member here today, since we're so bipartisan on this bill. The entity that rejected this good legislation that we passed is the very entity that said, oh, but when it happens to us, pay me. So that is the concern. That's why I think this is so timely, so appropriate. Let's pass this. We're going to try to encourage Leader Scalise to put this on the floor ASAP, and we will pass it, which I think is all good. Now we yield to the gentleman, and he can yield to the...
Hey, I'll yield to you, Mr. Goldman, but when there's 15 seconds left, I'm taking my time back, so go ahead.
You got it. All I want to say is I support this bill. I think it's a good balance. I was not trying to draw a distinction or in any opposition to this bill. I do think that we need to consider law enforcement functions and the need for secrecy in a law enforcement investigation, but this strikes a good balance and it still allows for that, so I support it. I yield back.
Okay, well, okay, I let you go even longer, Mr. Goldman. There you go.
It's because I was agreeing with you.
You are correct, sir. Yeah, Mr. Chairman, yield back to you.
Gentleman yields back. The question occurs on the technical amendment offered by the gentleman from Wisconsin. All those in favor say aye. Aye. Those opposed, no. The amendment is adopted. The question now occurs on the amendment, the amended amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye.
Aye.
Those opposed, nay. The ayes have it. In the opinion of the chair, the ayes have it. Oh, no, we got it. The question now is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the bill is to be reported favorably. The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill is reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.